And Dina, please, the floor is yours. Thank you.
Thank you very much, Wendy. Thank you for inviting me to be part of this conversation. I'll share my screen. I hope everyone can see it. So I'll be talking today about a paper on critical competition law and economics. And I'm really looking forward to the discussion with everyone here around the Zoom room. So just as a backdrop on where the paper comes in, so this is a research that I've put together for a paper that I was invited to contribute by Justin, Ilyas, and Stavros in a handbook that they're putting together on theoretical foundation of antitrust and competition law. So this is basically the paper that I've put together for this edited volume that I'm hopefully is going to be forthcoming by Cambridge University Press next year. So I chose to focus on this specific paper, but it also ties into much of the research and the work that I've been putting together over the past couple of years on a critical perspective to competition law. And the backdrop against which this research is set is the starting point, in a sense, is the malleability of competition law. So everyone has, or everyone is in agreement that competition laws can and have and continue to be used for many other perspectives than, sorry, I don't know where I put my slides now. Yeah. They are so malleable that we can use them and have been using them for purposes other than pure competition law or pure competition purposes. They're so malleable that there's a lot of disagreement about what really is the purpose. This has opened the door for conversations about ways to use competition law more critically. But also there has been lately a lot of discussions about what really is the purpose of competition law, particularly against the backdrop of a complete failure of these laws to achieve sort of their namesake, namely to increase competition. So this has led many of the academics and scholars that have become known as the neo-Brandeisians to formulate a critique that is nonetheless still centered around this notion of perfect competition and a desirability to achieve a competitive market structure that in their work comes off as an ideal against which our organization of the market should be set. So my work has generally been very critical about these perspectives, not the neo-Brandeisians per se, but generally the perspectives of trying to aim at achieving more and more competition, especially that much of our presumption about how these markets work are in a sense built on some false assumptions. And this particular research and this particular paper zooms into some of these very nuanced critiques against which much of the normative analysis can be placed. Now, what I want to say at the outset is that this is very critical in terms of looking at competition law, not just in the global north or in developed countries, but also how it has been exported to the global south. So to a large extent, the laws as they've been transplanted and imposed into many countries around the globe, particularly in the south, have been modeled on particularly European laws. And what I want to do with this paper is try to put some of these critical perspectives out there that are equally applicable and not particularly centered around the global south, which is what I've been mostly working on over the past many years. Now, the reason I think this is pertinent and this is important to talk about, not only the neo-Brandeisians as a critical movement that has sort of set the stage for us to be able to engage with more critical voices, but that the rise of big tech and the rise of monopolies and the concentrations of market further and further, rising prices, inequality, there's generally a wide consensus that competition laws have failed to achieve its basic presumption, which is increasing competitive markets. Now, I try to argue that one of the reasons they have failed to achieve some of these outcomes and to eliminate inequality or to reduce prices or to increase competition is that we have been focusing on a notion of competition as an absolute ideal. And that's exactly where the paper steps in, is that we are obsessed with a neoliberal understanding of competition and competitive markets that has carried a lot of the ills of capitalism that we're seeing over and over again. So to be able to zoom into these critiques, I put forward these three critical perspectives and three moves or three issues that I focus on in this paper. First is the presumption of impartiality and neutrality of market transactions. The second is the indeterminacy of competition law and policy. And the third critique is the ability to explore alternative market structure, particularly market structure that have more distributive considerations. So if we go to the different critiques, starting with the impartiality and the neutrality critique, what I work on here and what I try to explore here is that the heart of these liberal market structure is our understanding of freedom of actors that has played a fundamental role in how we think about these market interactions and exchanges. And here, the notion of freedom is central, and the notion of freedom is so central that it gives rise to this understanding of some sort of impartiality and neutrality of the market. And this is coming from a neoclassical understanding of markets. We think about the different actors, particularly this ideal actor of Homo economicus. He or she is this perfect actor that is rational, that is able to perfectly interpret all the signals, particularly price signals, and translate them into interactions, which invites a very anti-paternalist move in a sense, because we don't need anyone to tell this ideal, rational, perfect Homo economicus how to behave. Neither state nor regulation. The market is all they need in terms of absorbing these signals and behaving accordingly. And this has, of course, fed into a presumption of efficient market transactions that are voluntary. As soon as the transactions are voluntary, as soon as actors are free to behave in a certain way or another, then this necessarily will increase efficiency. However, any involuntary transaction, any forced redistribution will automatically be inefficient. So this is all grounded in this understanding of, on the one hand, this freedom of actors, but also the market as the ideal space to organize these different interactions of the players. Now, the critical move here is to show that, well, this is based on wrong assumption, and I don't go into each one of them. Of course, there's the critique of the rationality assumption and so on. But what I focus on here is just simply that in building up our market understanding around these presumptions and assumptions, we ignore an important aspect, which is the initial distribution of property and rights. So all actors in any given market don't have the same set of entitlements, don't have the same ownership rights, don't have the same bargaining abilities, and therefore there is a very strong unequal bargaining arrangements that results in the market, which in a sense automatically criticizes our ability to think about these markets as impartial and neutral, since we each have different market powers and different bargaining powers that come with our interactions. How can we assume that we're all the same and can behave in a certain way? And this is not a new critique, and in the paper I illustrate how this critique has been central to the Marxist critiques, but also central to the more legal realist critiques, particularly Robert Hale's work, and his notion of coercion. And his notion of coercion is very interesting when we want to zoom back into competition law, because his notion of coercion is set in law as the background rules. So how these different actors have these different bargaining abilities and bargaining strength in the market is a function of legal entitlements, how the law is here playing a role in setting these different entitlements, affecting not only the ability of the parties to bargain in a certain way, given the alternatives that they have in front of them, but also how this affects the outcomes and the distributions that come from there. So the market is in a sense constantly organized in a way that coerces the weak by the strong. And the minute we acknowledge that, we realize that law in general, and competition law here as the matter of my paper, can play a fundamental role in changing these bargaining arrangements and changing the set of entitlements and power that comes with it. And the basic idea is very simply is that property law, but also contract and criminal law, but also competition law, set what is called the rules of the game of the economic struggle. And the minute we recognize the role of law to set the tone, basically, of these economic bargainings or struggles, then we can use, again, law to redistribute and to rebalance the bargaining power of these different players, particularly towards the least powerful or the weaker parties. So what I argue is that since our entire market framing is based on these false assumptions of equality and freedom, it carries with it a sense of unworthy pretensions of impartiality and neutrality. And the minute we recognize that the market is not impartial and it's not neutral, then we can actually design law that recalibrate these bargaining powers of the weaker parties particularly. And I argue that competition law does play a fundamental role in this regard. It has played this role repeatedly by trying to protect workers, for example, in cases like Albany, but also in particular laws, for example, the South African competition law that I use as an example, where competition law has been used to protect and to redistribute towards racially disadvantaged groups, so Blacks in South Africa. The law has been repeatedly used to try to bring a redistributive agenda and redistributive objectives, taking the racial injustices that they've suffered from into account. And I argue that these distributive policies give parties this sense of entitlement that then can be used to empower them in the next bargaining arrangements. So in a sense, this is borrowing from this idea of bargaining in the shadow of the law, that we are constantly sort of bound by the set of legal rules or background rules and sense of entitlements that then help the parties bargain. So even if the competition law will not at every instant redistribute towards the weaker party, knowing that the law protects the weaker parties, for example, workers or Blacks in South Africa, this will give them a sense of entitlement that will then affect their bargaining arrangements in the market. So this is the first critique that I put out there. And I think once we change the lens and the perspective to recognize that the markets are neither impartial nor neutral, which are not new moves. So these are moves that have been repeatedly used by critical legal scholars, but also by the legal realists and progressive economists. And once we recognize that and change our perspective, then competition law can do a lot more than what is, to a large extent, currently part of the arsenal of tools that are being used. The second move that I do in the paper, and the second critique, is that I centralize the notion of indeterminacy. And the idea that I try to put forward here, which is, again, not a new idea, but has been a repeated move by many critical scholars, is that the entire enterprise here of competition law is, to a large extent, sort of embedded in an indeterminate setup, whether it is an indeterminate setup in terms of what are the outcomes, but the goals, but also when and how will competition authorities intervene, to what extent, which creates this sense of indeterminacy at every step in the enforcement process and in the entire enterprise. So whether we look at, for example, the notion of consumer welfare, there has been huge debates, not just in the enforcement circles, but also in academic circle, what it really means, how can we measure it, who does it reach, are they the direct consumers, the indirect consumers, there are contradicting case law, and there is no determinate understanding of what we mean by consumer welfare, although it is the notion that sort of organizes most of our, or has been organizing most of our competition law activities in the enforcement circles, but also in academic circles over many, many years, until recently, where this has been slightly put into question. And similarly, what I do here in a more or less descriptive sort of pattern is to show that even if we don't necessarily focus on consumer welfare, but the other notions that have been particularly relevant in competition law, even these, we don't always know what we mean when we refer to them. So when we talk about productive efficiency or economic efficiency or even dynamic efficiency, what is it exactly that we mean? How can we measure it? When we say that we should centralize enforcement on efficiency, which one of these three do we mean? If we decide to, instead of efficiency, center competition law around what we call the non-efficiency goals, again, What exactly do we mean? How do we enforce that? What do we want to achieve with it? Are these development goals? Is it about sustainability? Is it about fairness? Is it about equality? And even if it is, well, how do we measure it? And so on and so forth. So I'm going to spare you. You get the message, and that's exactly what I try to do here with the second move as a second critique of one of the basic assumption that, or one of the basic critical moves, is to illustrate some of these indeterminacies and systematic problems in trying to identify the exact outcomes that are desired. And then the final critical move that I put forward in this paper is that once we have recognized the problems that we have, we also need to question the desirable ideal that competition law has been geared towards, which is the ideal of perfect competition. So this ties back to what I said in my introductory remarks, is that most competition laws and most competition enforcement has been geared towards this ideal that is hailed as the perfect market, or the ideal market structure, that is part of a general neoliberal development agenda, particularly relevant in the global South. So we see repeatedly the move and the motto of the more competition, the merrier, just increase atomistic competition. Any kind of collaboration is undesirable. And what I try to put forward in this critique is not to say that, well, actually competition is not good and we should desire more concentrated market. That's not the move at all. But the move is actually to be able to nuance our ideal of this perfect competition and to realize that in the pursuit of this ideal, many of the ills of the markets that we are seeing around us have its roots in some of these notions. So, for example, one way to go about it is to look historically into what have countries done on their way towards development. And actually, and many have written about that, Hadjun Chang and others, is that at many moments in the development of countries, particularly in the global South, what was more relevant than competition have been attempts at creating what is called industrial policy. So these have been systematically used as moves to either protect national champions or to create a level playing field, or to expand out exports, or to provide national products to rely less on imports. All of these issues have been important policies that have been pursued, often in alignment with competition enforcement, that is today no longer possible, especially in the global South, because of the laws that are adopted are modeling the current state of laws in the global North that don't take these issues into account anymore. Now, this has been slightly changing, and I've wrote about that already, is that we see now repeatedly over and over attempts in the US and in other places around the world channels back into industrial policy as a carve out from competitive or competition enforcement. Now, what does that mean, and what is this sort of normative critique? Is that maybe antitrust law can be used, particularly, and here maybe we can zoom in back on the South, but it's not necessarily on the South, in a way to achieve what I call a protective antitrust policy. And this is a protective antitrust policy that is achieved through what I call strategic enforcement. So it's not across the board competition. Competition should not be desired for competition's sake, but there needs to be an ability to sort of find out the industries that at some point in their maybe nascent industries need to be protected until something happens, and then they can be subjected to a different organizational structure. And this fits with two main ideas that this critique is anchored towards. One is an idea that is very much influenced by the writing of an important economist, namely Samir Amin, on delinking. So this is very similar to others that have been interested in dependency theory. In a sense, for the South to be able to delink from this determinate relationship on the West, they need to be able to produce on their own. And in order for them to produce on their own, sometimes they will need the selective enforcement of antitrust laws to protect some industry so that they can rely less, for example, on imports. And the other main idea is that this is related to a desire to be able to capture some of the surplus that is generated by these firms and to redistribute that back to different stakeholders. And I explore ideas that I've written about in other places before as well to basically socialize the firm by putting into the ownership structure of the firm its different stakeholders, whether it's the workers, whether it is the consumers that are buying from the firm or the communities around it, in a way not that different from utility rate regulation at the turn of the century, to sort of capture some of the surplus, to limit the ability of property owners to use their property to its fullest by taking out some of that surplus and redistributing it back to the community and to the stakeholders that can be identified. Now, the reason I think this is important is that the problem in the pursuit of industrial policy per se is that we often recognize that these firms will create more powerful entities, and in the creation of these more powerful entities, some of those that would be either working there or buying the product will be necessarily harmed or exploited. And the idea is to make sure that in the pursuit of these industrial policies, these stakeholders, particularly those that could be suffering the most from these relationships, are protected through that sort of redistributive mechanism. So to conclude, and I'm happy to discuss any of these ideas more in the Q&A. What I try to do with this, and it's a really short paper, what I try to do with this short intervention is to put out these critiques, particularly of neutrality, determinacy, and in a sense, efficiency, or efficiency as an outcome of perfect competition, to allow competition laws and competition enforcement and policy in general to be freed, in a sense, to be freed from our neoliberal understanding or neoclassical economic understanding of how market works, so that we can address, in my opinion, more pertinent consideration that can help us create more just societies. So in a way, this is an imaginary ideal, recognizing that competition laws, given that they're so malleable, again, where I started, they're so malleable, they can be used for different things. And in relaxing some of these assumptions that don't hold in the real world, we can free competition law to be able to address some of these other desirable outcomes, particularly outcomes that take inequality seriously, that think about racial injustices, as in as is happening with the South African competition law, think about the relationship between workers and the firms and employers in general, empowering these workers, empowering the weaker parties at every instance, think about sustainability, the environment, and all of these different issues in a way can play a role. And my idea is always that they don't need to play a systematic role. So my critique of the indeterminacy is not to say, well, competition law need to be determined about a single one identifiable outcome. On the contrary, the idea is that in these different moments, in these different enforcements, in these different contexts and these different countries, there will be different goals that will be desired. And these different desirabilities can change over time and can be adjusted and so on. And then just a final remark is that in exposing these critiques, we also expose some of the structural and systemic biases that are profoundly there in our understanding of the market. And in exposing these critiques, it's just one step, or just the first step, to be able to imagine these alternative possibilities that, as I said, can be different and can be contextualized, and everyone and every country and in whatever context, they can look differently and can be changed accordingly. So thank you very much for your attention, and I look forward to your comments and remarks.
Thank you so much, Dina, and within time, even better. So thank you so much. I've been speaking about systemic and structural biases. We're going to go and have Kati speak about feminism and competition law. The floor is yours. Thanks, Kati.
Yes, thank you very much. I think you can see the slides full screen. Is that correct? Okay. Yes, thank you very much for this invitation. And after the first presentation, I already know that this is a very interesting discussion, but also very much a discussion where we are going to talk about very similar things like inequalities, empowerment, biases, etc. So let me start with a question I often start this presentation with, and we will not have time to have all your answers, but you can type into the chat and I will have a look later on. So this is a book written by a Swedish journalist, economist, with the title of Who Cooked Adam Smith Dinner, which is a very basic question in economics. How do you get your dinner on the table? It sounds very easy and simple, but it's in fact a very complicated process. And the answer that Adam Smith himself would have given or has given is that it's not from the benevolence of the butcher, the brewer, or the baker that we expect our dinner, but from their regard to their own self-interest. Now, turning back to the question that Catherine Marsal has asked, so who cooked Adam Smith's dinner? Who cared for him? You may have guessed it was his wife. You may have guessed it was his mother. Well, it was his mother. He lived apparently all his life with his mother, who cared for him and most probably also cooked his dinner. So this shows, and shows very likely that Adam Smith's mother was not caring for Adam Smith out of self-interest, but probably out of pure love. And what this little example shows is that many of these activities like mothering and caring, cleaning the house, cooking, is up until today, if we look around, is still not part of our economic models and when we talk about markets and economies. And this is where my interest started, how these different power structures in society and in the economy intersect. So I will not go too much into detail. You will have to take it from me, but I think you will agree that so there are a lot of gender inequalities in our societies. It's often said that gender is socially constructed and deeply structurally embedded in society, but it also has very systematic links with the economy. So gender often influences the allocation of resources in the economy. And while the nature of the gender relations may vary across countries, jurisdictions, there is a general pattern that women have less economic resources, they have less autonomy at their disposal, and often they have less influence over decision making, again in markets and in economies. So we could say that gender inequality, and importantly not just gender, but together with other forms of inequality like class, race, age, geographic location, and many others, actually shape economic relationships, people's preferences, the choices that they make on markets, the purchasing decisions. And this is something that equally influences businesses and consumers as well. And now I think many examples come indeed, just like the previous presentation, maybe underlined from developing countries and maybe from the global south or in Europe, from Eastern Europe. But in fact, this is really the same thing, again, with a little bit different patterns also across all countries. So for example, in the Netherlands, a recent report, which was about emancipation and the position of women, also established that women are a lot more economically vulnerable, while 80% of the male Dutch population is economically independent. It's only for 2/3 of the women true. So we have it everywhere. I think it's a problem that plays a role across all our societies and once again, the economy as well. And this is what I am very much interested in. So I'm interested in gender as well and feminism, but I am actually very interested in these power structures that exist and how law can, what is the role of law to structure these, to control these, and maybe to change them. And I think there is an increasing realization as you see this report from Cseres about inequality, that coming closer to our subject, competition law, that market power, corporate power, does have a serious relationship with forms of inequalities. So as you see here, corporate power magnifies and exploits inequalities along the lines of gender, race, and other types of identities and inequalities. So this really shows that there is an intersection between these gender divisions and divisions in the economy. And that shows a little bit as well, already forward with what feminist researchers, social science researchers say, that market power is not just about firm behavior, but it can also lead to exclusion and marginalization of certain groups of people. And this report also gives a few examples, indeed, from the Global South, but I think it's something, again, I see also this being discussed in the Netherlands, how, for example, increased privatization and the presence of concentrated private economic power in essential public services like healthcare, education is indeed leading certain vulnerable groups to the margins and basically causing harm to these already vulnerable groups. So that comes closer to home. What are we supposed to do with all this in competition law, in the scholarship, in enforcement? So the question is gender really a relevant factor to which is worth exploring in the various analytical frameworks of competition law in the enforcement? Feminists would ask, and I will come in a moment to their methodology, they would really ask and center the discussion to how competition rules and the enforcement take account of this group. So women's experiences, preferences, and choices. Another question is how existing gender divisions and inequalities operate in markets, so this intersection between societies and markets, and is it relevant enough, again, as a factor to take into account in when we look at market processes, market power, or the behavior of market actors. Now we can have a discussion whether gender should be, again, another thing that we have to do with the competition authority also say, but I think that question has already been decided. Very much, I think many of you may know already the OECD's big project on gender and competition law, but do realize that this is actually a project which was started by Canada and the Canadian Competition Bureau, coming from their government policy, which is called Gender-Based Analysis Plus, which actually didn't require them to do something in competition law in the first place, but it required them to include that and mainstream it in their foreign policy, in their foreign trade policy. So where they got this question in itself, an interesting one, maybe also to Dina, was when they were about to conclude bilateral trade agreements, and the government asked, okay, but what are we supposed to say about competition law? And the Competition Bureau was, I don't know. So let's link up with the OECD, and that's how the project got rolling with the various, one of the projects you see here. We often refer to South Africa, indeed, because it has a constitutionally built-in structure and mechanism to address harm and, again, the interests of historically disadvantaged people. So it's happening certainly in these areas. There is also this lovely interview with outgoing Commissioner for Competition Law in the EU, Margaret Vestager, who in fact fully endorses that antitrust is definitely a place where we can play a role in fostering inclusion. And just for a moment, because I work very much in the field of EU law, and this is also a paper I have been struggling a lot with, so any comments are welcome. In the EU, there is also a constitutionally built system which actually obliges the Commission itself and all the institutions to mainstream and take gender equality considerations into account. The framing is not very strong, as you can see here, this article from the Treaty on the European Functioning of the European Union. It says that the EU shall aim, so it's not a very strong language, but it's constitutionally there. The EU has a very robust gender equality framework built on secondary legislation and also on treaty provisions. As you see, how to be integrated and enforced is, I think, still unclear, but the constitutional framing is certainly there. So that brings me to the question and to the topic for the presentation of, what can feminism offer here? And you could even ask, isn't it enough just to think about gender and just like the EU to implement considerations of gender equality? And feminists would say, and they have often said, not lawyers, but more the political economists, that what is missing, for example, in the EU is a feminist reading of gender equality. So you can indeed add women and then steer, as it has been also said, you can tick the box, but that is not what substantive equality would mean. These are just a few examples of feminist legal theorists, economists, data scientists. If we want to talk about feminism, and I think Giorgio will go maybe more into detail as he has done in his paper, it's a very, very diverse field. So there are very different discourses, there are different practices. It's very interdisciplinary, it's very multi-sided with different approaches, different ideologies, different identities, etc. So it's a very rich field. It's a field that developed over many years from the beginning, or the beginning of the 20th century in various waves, and again, schools and disciplines. So please bear that in mind. I haven't read all the literature. And I mostly, in my work, I have been reading and draw more on feminist legal theories, and I take it with a broad brush. Feminist economics, I have been reading a bit of philosophy because I am very interested in power and what feminists think about power. And also because, trying to see what could be relevant for competition law. Now, against this diversity, what they all agree on and what they all focus on is gender. Gender in an intersectional meaning, so women and non-binary people with all our personal identities. So we may come from the south or the north, east and west, different ages, different, again, geographical locations. What their strengths and added value, I think, can be, and that resonates very much also with Dina's presentation, is that they contextualize, they bring in a contextualized lens. They draw attention to the complexity of the economies. They draw attention to the complexity of the markets, that they are embedded, like my first example. That rational economic man does not exist in himself, but there are other economies, there are other activities that help, just like helped Adam Smith to write his brilliant books. These are all what should be, in a broader sense, taken into account when we think about markets, when we think about the behavior of market actors. So it's very much this complexity, this embeddedness of markets, and importantly, the human diversity. So the agency, when we think about, again, for us market actors, then feminists, and especially feminist economists, draw attention to this human diversity of both consumers and businesses. I'm happy to answer more questions about that, but I thought it would be also interesting to have a look at how it works in practice. So just to give you a few conceptual lenses and then a few examples, if time will allow me. So one way to start with, and you have to bear it with me, that I have a background from a long time ago in both competition law and consumer law. So very often I look at the consumer law side and consumers, but I think when we talk about exactly these feminist approaches, social science approaches, and gender, then we end up with their criticism of the standard behavior assumptions of market actors, these standard behavior assumptions in mainstream economics. And you can read it here. We come back indeed to the homo economicus, who is independent, unembedded agent without unpaid care responsibilities. So it's really the consumer scene, and not just in competition law, in consumer law actually, that is still also the standard. It's seen as a person with coherent and homogeneous and predictable preferences, without any social status, without personal identities. And it plays, if you think about it, in various parts of our competition law analysis. For example, the market definition I will come to, but also market power. It does play a relevant role how we see consumers. It does play a relevant role within this big debate about consumer welfare. So we talk about consumer welfare. We certainly don't talk about, or some people have been already talking about worker welfare. We could also talk about women welfare, of course. But so far, the framework has been very much one which gives distinctive preference to consumers and their economic well-being, without looking at consumers outside of the markets, without disaggregating who could be the subgroups of these consumers and what would be their identities. So it's really this gender-neutral consumer with rational preferences and the ability to substitute products and services in a perfect sense. But this is not a new discussion. And we mentioned workers. There have been already quite a lot of discussion, for example, in the EU and the European Parliament as one institution, about low-income consumers, about inflation, the role of competition law there, and whether those vulnerable groups could be also helped or protected by the use of competition law. And I leave the race topic to Greg, as he's much more an expert on that. But again, so the idea that we should go behind this concept of homo economicus and behind this neutral consumer who doesn't come from anywhere, doesn't live anywhere, with no preferences, I think we also pass that. What these approaches from feminism bring in is that they put very much spotlight to women, and again to the group who would identify with that. Another area where, and I will continue from here, and it's sort of also the language that I think feminism and many feminist social scientists use, is of course power. So in competition law, we often say that competition law is basically is an area of the law which structures markets, but most importantly, we focus on how market power is created, and once there is market power, how to control it. And I think there is a very nice parallel with, if you look and read how philosophers conceptualize power with regard to feminism. And they come to these three different ways of conceptualization of power, which is related to how resources are distributed and very much to domination and empowerment. So they came up with these three categories, like power over, power to, and power with. And when we talk about power over, that very much resonates with the lens of competition law. So domination and the presence of market power. Another paper probably is going to be to discuss empowerment, which I think resonates more with consumer law. At least there has been a lot of discussion about that. So these are just a few thoughts on concepts. And do I have time still to go into a few examples? Okay. Because I think that's usually what the question that we get is, this is all good and sounds very convincing, but again, a competition authority with limited resources will ask, do I have to do this, and what am I supposed to do with it? Since I think power is really an intersecting important concept, but also analytical frame of feminist approaches and a focus in competition law, I think market power is something very much worth exploring. And that starts with actually defining what is a relevant market, and within that relevant market, where the market power exists. And looking at, and I saw Magalise, I think also in this presentation or in the audience, I very much liked and now reread several times her work on the definition of the relevant market and what is its function in competition law. And it again resonates very nicely because gender can be thought about in the competition law framework as indeed being one of the factors that could be taken into account when the relevant market is defined. So it can become part of this reference framework. It affects consumers' preferences. It affects their purchasing decisions, and in that sense, it should have implications for investigating market power and what the effects of that is on competition law, on competition. The EU has just revised its notice concerning the relevant market, and it comes very close to taking, for example, gender into account as a factor, as they also announced that past development and especially digitalization and the effects of that are taken into account, as well as language, cultural differences, geography, when consumer preferences, substitutability is looked at. But you can guess already that gender is not part of that. But I think it would be worth thinking about how it could be part of that framework. And there is one study within the OECD project which did look into the relevance of gender. That's a study by Cseres, where what they did is they went back to some of their studies that they have done for competition authorities, and they took the data that they have used and they disaggregated it along gender lines. They have only done it in a binary way. You would have questions about that, realizing that this may not be enough. And looked at what would have been in various cases when defining the relevant market. Would gender make a difference to the decision, to the conclusion that they have made? And it seems that it does. So perhaps not in each and every case, and not in each and every sector and firm behavior, but it seems, and that's something that we also hear a lot with regard to digital markets and data scientists, that looking at data, 1 minute? Yes, in a disaggregate way is really an important tool, especially in competition law, which is data and evidence-based, to further pursue. Okay, then please allow me just to say something about market power, moving on from the relevant market. That's something I'm still working on, and I came up with this, and after that I read Giorgio's paper, and as always, he frames it a little bit better, but this is what I came up with. So how gender contributes and is part of what is a big discussion already now, that there are new sources of, there are new power balances, and we have to look at various sources we have not yet looked at. So how consumer biases, which could include gender, how consumer vulnerabilities, especially in digital markets, contribute to certain firms' market power, how it strengthens, how it makes entry more difficult, and how it strengthens their economic power in the market. For example, take targeted personalized advertising for cars. They are mostly, if you look online, they are mostly addressed to men, while we know that most of the purchase decisions are taken by women, which means that often women will not get the type of information that would be necessary for purchasing a car. So this stereotyping and these biases and inequalities that we know in digital markets being magnified by the use of algorithms actually could lead in themselves to disadvantages for female consumers. And what I have been thinking about is how you operationalize that is to think about, and here I reached out to consumer law scholars who have been also thinking about, 5 seconds, thinking about vulnerabilities, consumer vulnerabilities in markets, is to call for some kind of qualified consumer harm. So a harm which occurs to certain, again, subgroups of consumers where they see a reduction of their consumer welfare, and we should be giving some kind of weighted value to this harm in our analysis. I will then stop here. On my slides, you will see one more issue, but I write quite a lot about that. And thank you very much for your attention. I'm looking forward to the questions.
Thank you very much, Kati. Sorry, we just have to keep to time, but I'm sure if there will be questions and you can go more in detail when the Q&A comes along. So thank you so much. Well, so after feminism, we are now turning to Greg Day, who will talk to us about US antitrust and the problem of race. The floor is yours. Thank you, Greg.
Thank you so much, everyone. I really appreciate the ability to contribute to this conversation. Is everything looking good? Good, fantastic. Okay, so the first thing I wanted to, I just wanted to discuss is with my research that I've often done with a guy at my good friend and colleague at Fordham University, Bennett Capers, who is a race scholar, is a lot of discuss how anti-competitive behaviors aren't always evenly spread or sort of like colorblindly spread across society, but oftentimes they can be intentionally and other times intentionally sort of targeting people of color, and oftentimes they have sort of what we call in the United States a disparate impact, meaning that it's a sort of a seemingly colorblind neutral policy that happens to disproportionately allocate harms across different communities. And so talking a little more just sort of about the intentional sides. So, I mean, a lot of these are more historical practices when there was less, in the United States, there were less safeguards against sort of like intentional racist behavior, especially from governments or private actors. But one is that, so in the United States, labor unions had traditionally maintained white workforces. And when they did so, it was very clearly that they discussed people of color, especially Black workers, as competition. And also, it's notable in the United States that our antitrust laws do protect labor, and labor is becoming a much more increasingly focus of antitrust laws. So competition for labor is kind of now at the heart of modern antitrust laws, and by that, labor unions didn't only exclude Black people and certain types of immigrants, but they also have petitioned government for laws. Like one was the Davis-Bacon Act, and the Davis-Bacon Act was to have the seemingly laudable goal of raising the local prevailing wage meaning that that you had to pay labor, whatever the labor unions got. And this seemed like a good law because it was supposedly raise the wages of local labor. The issue is that unions didn't want to be undersold by non-unionized labor. So the goal was to prevent employers or dissuade them from hiring black labor. And there's even a lot of the congressmen on record called black labor bootleg labor and said it is labor of that sort that is in competition with white labor throughout the country. So the intention of this law was very clearly to prevent black labor from competing against white labor. It's classically sort of anti-competitive. Other types of laws that in the United States, there's a long history of especially locales, cities and states trying to prevent Chinese people from competing in the United States, especially their businesses. There's a really great article in the Duke Law Journal called "The War Against Chinese Restaurants," and the fear was that Chinese restaurants would come in and take business away from sort of like Native American restaurants. Also, there was in San Francisco, there was a sort of a famous case where back in, I think it was the early 1900s, where San Francisco passed a law against tin roofs on laundromats. And the reason why was because only the laundromats in Chinese neighborhoods owned by Chinese people had tin roofs. And so it was sort of like a facially neutral way that was very intentionally meant to prevent competition. There's also been businesses also boycotted and had harassment campaigns against immigrants of color. One in the 1980s, there was a really big. There's one of the few antitrust cases that actually talked about sort of like race and how it was involved. Was in Texas, Vietnamese people had begun to immigrate into the United States, and they were prolific shrimpers. And they were shrimping in the Texas communities where people did not like the competition posed by Vietnamese people. And they even sort of like outsourced a lot of their behavior to the Ku Klux Klan, who threatened local people that would rent their docks to Vietnamese shrimpers. They threatened people that would do it. They would burn effigies. And the antitrust case at the end, the judge said two things. He says, one, I mean, this is classically anti-competitive. I mean, this was sort of used a lot of fear tactics meant to kind of prevent competition. And then also there was a level of just pure xenophobia about newcomers into neighborhoods. So it was really difficult to tell where the racism started and the anti-competitive behavior ended, or vice versa, which one drove which one. Sort of like in more in more, and also historically, so like a lot of professions like lawyers, they expressly forbid Black people from competing in their markets or from being licensed through for decades. It was very common in a lot of states like Maryland, where no Black person could ever practice law. So in terms of, there's also a lot of historical laws that were very clearly intended. A lot of them were immigration laws, other of them were labor laws, but they were very clear. Like what the United States had passed in the Chinese Exclusion Act, and that was and all the congressmen on record described Chinese labor as unfair competition because they were willing to undersell. There was other anti-Mexican laws in the United States. There's a couple where the quotes from the senators on record were, Mexican laborers come here in competition with American workmen, and those who come in from that country are less desirable citizens. Mexicans take the place of American citizens in the factories and on the farm because of the unfair competition of cheap Mexican labor. The Page Act of 1875 sought to end the danger of Chinese labor and immoral Chinese women. The Anti-Coolie Act sought to protect free white labor against competition with Chinese labor. And even like restrictive covenants were reduced the competition for housing. So in the United States, there was a lot of times when in real estate, they would bake into the deeds that you could never sell the land to Black people or Semitic people. And it was intended to keep to prevent competition, to prevent people of color from competing for like sort of the most desirable land in a lot of neighborhoods. There's also a lot of what we call disparate impact, where anti-competitive behavior maybe isn't targeted but happens to. So a lot of, and like currently like New York City, it's almost impossible to run to get a license to run like a food cart or like a food truck on the stands. And there's a lot of businesses that have talked about the need for limiting licensing because they're taking our jobs, meaning that they're competing against us. But frequently the people who run the food trucks are a lot of times like Middle Eastern or Mexican immigrants. The cosmetology industry has sought to, in the United States, require a license to do hair braiding, even though most cosmetology license education doesn't require a single hour of hair braiding, but the people that generally hair braid are African women in the United States. There's also exploitation of monopsony power in the labor market. There's a lot of like non-competes or no poaching agreements that are expressly that target sort of like low-income labor that disproportionately affects people of color. Another thing is when a lot of times when mergers are blessed in the United States, like food, grocery, and banking mergers, the hope is that consolidations will create these big, luxurious grocery stores or efficient banks, but they also reduce the number of banks and grocery stores. The issue is that yeah, I mean, a lot of the more affluent neighborhoods tend to receive sort of like these big, great grocery stores, but oftentimes it's resulted in what we call food deserts, banking deserts, childcare deserts, and healthcare deserts in low-income neighborhoods where the greatest harms are inflicted on generally communities of color and low-income communities. There's also a lot of states that pass laws and rules meant to benefit politically they're meant to help serve businesses. Like one is called the CON, the certificate of need, where basically states there's limited competition unless you can show a certain volume of people need the service. So one example is in Kentucky, you need to show that certain volume of people need for senior care, for sort of old age senior care, and you need to show certain hundreds or thousands of people need this care. The problem, and it's intentionally meant to limit competition. The problem is that especially like Nepalese immigrants in Kentucky can't receive care for their specific group because their need falls below what the certificate of need requires. So it shows that these attempts to limit competition, and a lot of times intentionally have been meant to affect people of color, but oftentimes, and especially more modernly, it's like a disparate impact where it happens to disproportionately do so. But when it comes to antitrust, antitrust it kind of follows a colorblind approach where it doesn't view things, at least in the United States, or it doesn't view race or a lot of times subclasses as part of the analysis. In many instances, there's times where when it seems like discrimination occurs, it's called like a social injury. Like American antitrust is exclusively economic. You have to show economic harm. And Hibba Hafiz showed in an article that oftentimes if you show that like you discriminated against somebody economically because you have a bigoted intent, that can actually even serve as a defense because it shows that your goal was completely social and not not competitive as antitrust requires. Oftentimes, antitrust is just a pure numbers game where it's sort of where it looks at or American antitrust, we look at like when an activity happens, it's anti-competitive if more people are hurt than they're benefit, but more people benefit than are hurt, then it's fine. And with that, if dominant communities benefit, but low-income communities or people of color are hurt, it will generally be considered pro-competitive because simply a greater number of people won, despite sort of how the impact is disproportionately spread across society. And also antitrust in America under the rule of reason has this big pro-competitive justification where we assume most activities are actually pro-competitive. And so for these sort of, and there's also something called state action immunity. And one issue with state action immunity is that anytime a state enters into anti-competitive behavior, we generally assume that almost all the presumptions go with that. It is blanketed. So states can enter into what could be discriminatory efforts, like a lot of the licensing regimes can be blessed through because they're sort of excluded from antitrust law. Also, if something that has a pro-social there's a exclusionary conduct that has like a pro-social end result, that also wouldn't qualify, because again, antitrust is economic. There was one case where there was a bunch of trial lawyers in Washington, D.C. who colluded together because they were getting underpaid. And one of their arguments is that they refused to work until their wages were set, and that's sort of like a group boycott, which is illegal. And they argued that they can only help indigent clients who are primarily people of color if they're paid more. And the court absolutely agreed. And the Supreme Court said, yeah, this getting paid more would absolutely help your ability, but this social justification isn't part of antitrust law, and so we are therefore, required to dismiss it. That said, there is this increasing argument in sort of debate in the United States about whether race or how race should fall into antitrust. A lot of scholars still are very clear that antitrust is not meant to cure social issues or worry about things like discrimination. But as you can see by having discussions and talks like this, it's becoming, there's an increasing appetite for at least revisiting it. And I've heard from people in U.S. government like the DOJ and the FTC, where it seems like they're very keen to like reconsider how sort of modern antitrust works. So part of this is that in actuality, we have a lot of room to reconsider antitrust, because one thing, the Sherman Act in the United States is based upon very few words and texts. It's essentially when it was enacted, it was of this very broad grant of power that the Congress said courts should figure out. And so because of that, a lot of these things about these limitations of antitrust, about economic harms and consumer welfare, is actually came about in the last couple of decades. And so it gives us a lot of room to reconsider it. And the things that need to be reconsidered is oftentimes how people of color suffer greater switching costs, in the sense that more affluent people, when mergers increase hospital costs, more affluent people tend to have insurance, so their costs tend to be lesser than people who are uninsured in the United States, and who oftentimes have to turn to like self-medication or substandard ways of healing themselves. When banks merge, and if the cost for loans goes up in bank deserts, when primarily people in communities of color, they turn to what's called title ponds and check cashing joints, where they're essentially getting quasi banking services that come at much higher costs. In essence, their costs are much greater than in affluent communities. We've also seen that businesses are just more likely to compete for white dollars, even holding income constant. One sort of absurd example was that the beauty industry didn't provide adequate beauty supplies to people of color until the star Rihanna started a company in 2016, which is an immediate success that sparked other companies to follow suit. But it was sort of amazing that there was actually millions and millions of dollars that were available that the companies just decided not to compete over. And in terms of healthcare, not only do Black people tend to get worse treatment, but we found that like in medical textbooks, oftentimes in the United States, a lot of the colors or pictures are exclusively meant for like white patients. So we're not seeing competition being evenly distributed. And this is something that antitrust needs to consider when it views consolidation as a benefit. And so one of the biggest arguments is that discrimination, whether it's implicit or intentional, should be looked at as a type of like allocative inefficiency, which is something that antitrust in the United States highly considers. When you're distributing goods and economic wealth based upon not like a good's most productive use, but based upon essentially race, you're not distributing wealth or capital or value in terms of their most efficient ways. And under American antitrust, I mean, that's sort of considered like classically an antitrust offense. So a lot of like what me and Bennett's research has been is to show just the pure, not even revisioning antitrust necessarily as something different than it is, but just under the pure consumer welfare Chicago school model, this is just classically inefficient in a way that harms consumer welfare. And it's also worth knowing, and which I've already kind of brought up, is the role of rhetoric, because oftentimes when we talk about sort of the role of race and sort of like, bigotry, when people are taught, oftentimes when we talk about the competition of people of color, we oftentimes use the words like unfair or anti-competitive, like sort of like when I mentioned like the laws against Mexican laborers, they talk about them being less desirable citizens, kind of talking about their competition as being something that it shouldn't be embraced, or that even because tradition or antitrust, if you charge less for a product, I mean, that's considered a pure version of competition. That is considered the essence of competition, charging less, to kind of beat your competitor and improving consumer welfare. But oftentimes when it came to especially immigrants of color who've come to the United States, they're sort of dressing them up as people as immoral, failing to fit into society in ways of like suggesting that their competition is unfair rather than actually a classic way of competing. So it's this, you especially saw that in the Vietnamese shrimping case. So it's kind of fascinating to see how the rhetoric has merged with describing just classic ways of competition, such as like the food trucks that offer really cheap and amazing food, yet describing them as taking jobs, whereas normally we'd say they're competing for jobs. So in addition, and I think this is one thing that I find, extremely interesting, is that so American antitrust law is actually based upon it arose out of the common law of competition from England. It was adopted before we ever enacted the Sherman Act. And one thing that was really kind of fascinating was that in the common law that was imported into the states before the Sherman Act, the common law of competition in England actually has a rich history of protecting foreign traders, because in England it was very common for traders to engage in anti-competitive behavior to eliminate, sort of like, to protect their jobs, and English courts struck those down as monopolies. And a lot of companies in England, a lot of English companies argued that if you call this a monopoly, our anti-competitive behavior against foreigners, and we wouldn't be able, like, English labor would lose out. But nevertheless, there's a rich history of antitrust through the common law of competition, protecting things like people of color and especially immigrants from other places. So some of the ideas that we brought, that we're wondering, is if things like racial animus should be considered something that's like anti-competitive. There's one case that was called Rowe Entertainment versus William Moore Agency, where a group of concert promoters in the United States refused to hire Black entertainers and only white entertainers, and they brought in Antitrust Act. One thing that was interesting about the case was that they found that there wasn't really much of that their exclusion was based upon racism. That was purely what it was. And so the antitrust court dismissed the case and said, we don't see like how you're gaining an economic advantage by protecting white entertainers and not hiring Black entertainers. And so because of this, there wasn't this like economic goal, but there was like a social goal behind it. So maybe one thing to kind of reconsider was, when you look at classically anti-competitive behaviors that maybe achieve sort of like a bigoted goal versus a purely economic goal, maybe that's something antitrust should revisit, because again, animus can even serve as a defense like it did in this case. Other things that we're sort of curious about is sort of like complementing equal protection. But there's an additional area that I think that me and my co-author Bennett have discussed that we find incredibly interesting about sort of like the role of race in American antitrust law that I think could help inform how antitrust moves forward. So the Sherman Act came out in 1890 due to the rise of trusts. But this actually wasn't the beginning of anti-monopoly legislation in the United States. Following the Civil War in the United States, so the Civil War was fought over slavery, to end slavery, and then after the Civil War, a lot of the southern states were unwilling to give up sort of like the slavery economy, so they enacted things called the Black Codes, which essentially forbid Black people from competing against white labor, whether as a fisherman or as a clerk or in many different sorts of jobs. So the Reconstruction amendments that were passed after the Civil War tried to give equal protection to people of color in the United States. What is sort of fundamentally fascinating, and that has been lost in sort of the tour of history, is that John Sherman, the namesake of the Sherman Act, was heavily involved in the Reconstruction amendments like the 14th Amendment. And back then, they were also they considered a monopoly had a different definition back then. It was essentially any sort of grant of government privilege to another party. And abolitionists had begun calling slavery in the Black Codes a monopoly because it was a government grant that privileged one party and hurt other parties. So they frequently used in this Reconstruction period, the terms of monopolies. And when the 14th Amendment was passed, parts of the 14th Amendment and 13th Amendment were described as anti-monopoly provisions, specifically anti-monopoly provisions that were meant to help Black people. There's a bunch of cases that we don't need to go into. If you ever want to email me, I'm happy to talk about them, that essentially eroded this type of this law. But John Sherman, who was the namesake of the Sherman Act, was instrumental in a lot of the Reconstruction Act, and a lot of the speeches on the House floor in passing the 14th Amendment talked about the dangers of monopolies and how Black people were being harmed by monopolies, and all these monopolies were meant to oppress them and repress them. And so it's our argument that Ben and I have recently made that when John Sherman enacted the Sherman Act, only about 20 years later, that Reconstruction was fresh in his mind. It was only because of the fall of a lot of the anti-monopoly provisions in the 14th Amendment was the Sherman Act even perhaps necessary. So we kind of argue that a lot of the common law that was built into the Sherman Act, that he expressly said, I'm building this off the Sherman Act and the right to work that was meant to protect Black people. We think that the conscientiousness of racism and how monopolies affect race and people of color was in fact an integral part of like the enactment of the Sherman Act.
1 minute.
I am done. But
Really?
Yeah, no, thank you. I appreciate it. But I'm really happy to answer any questions and talk more about this. And I really appreciate hearing everyone else's talks as well.
Thank you so much, Greg. That was a fascinating tour through a history of all the different cases and laws, etc., that discriminated against on the basis of race. So now we have Giorgio coming in to provide his thoughts and comments on these three presentations. The floor is yours. Thanks, Giorgio.
Thanks, Wendy, and thank you to the three speakers for the wonderful presentations. And I was fortunate to have a look at their papers before today, so my comments are going to be based on the papers as well as what they've said now. So I think it's really fascinating that there's such diversity of ways of writing about more or less the same thing, how to bring excluded interests within the scope of antitrust. I have, I think, four lines of commentary. I think the general point I wanted to begin with is that competition law is designed to, in a way, curb the excesses of a capitalist system. So Kati says in her paper, laws structure markets. And indeed, some laws, like the rules of property and contracts, are there to facilitate market developments. Contrarily, competition law places limits on how freedom of contract and property rights may be exercised. So to a certain extent, competition law is already so built in to cure the market failures that obtain from an unrestricted markets. Nevertheless, some of the criticisms in some of the papers are more about the workings of the market as such. So references to neoliberalism, inequality of initial allocation are issues which are perhaps going a little bit beyond what antitrust can do to resolve. Now, all three speakers begin, this is my first point, with suggesting that competition law is flexible. So Dina spoke about indeterminate aims. Kati referred to the EU treaties that has integration clauses that mandate the integration of a variety of interests within the scope of each discrete rule. And Greg spoke of the open textured framing of the Sherman Act and perhaps even the legislative history leading us towards a broader way of thinking about antitrust to enrich it. But at the same time, if we go back to Dina's original point in the paper, antitrust has not delivered even on its own terms to deliver competition. So if antitrust is even in its reduced form as a consumer welfare prescription hasn't delivered, should we really be hopeful about whether making a recommendation about extending the reach of antitrust to deal with other interests which have not yet been integrated is that really worth fighting for, since antitrust itself appears more performative than substantive? You know, it can do a few merger cases, but most mergers are allowed. It can take a few cartel cases, but it takes much fewer cartel cases than exist. So should we really try to expand the reach of antitrust, given that it's, even in its limited form, it doesn't do very much? And here the challenge is even greater. If I quote from Gregory's paper, he says, at one point, markets are less likely to respond to minority consumers until competition increases beyond the level required for white people. So it suggests that in order to create competitive markets, we need to do a lot more work with competition law than we do at the moment. And so my first question is competition law up to the task of reaching these broader ambitions of addressing racial inequalities, gender inequalities, and more broadly, economic inequalities? So I guess, you know, good ideas can be generated. The question is, can competition law deliver? Second point is whether, if competition does deliver, whether competition enforcement is enough to address the issues that these papers have touched upon. Of course, we can construct legal standards by which a merger may be blocked by designing a theory of harm that is gender inclusive or race inclusive. For example, does a merger create power in a merged entity that gives the merged entity the power to squeeze workers in a particular geographical market where most of the workers affected are women or members of a racial minority? So we can determine that these people are less mobile, so they cannot move, and therefore they're prey to one or two employers. If these two employers merge, we can have monopoly power generated, which could predominantly harm a racial minority. We could even be more direct, like the examples that Dina has in her paper about South Africa, where a merger analysis includes the impact on historically disadvantaged groups. But my question is the contribution of doing this to achieving or improving gender and race equality sufficiently large to make this worthwhile as an effort? So my point is not that which has been made by others, and I think in some of the papers, you know, people like Louis Kaplow and Herb Havenkamp have said, you know, if you want to do inequality, there are better rules out there that can do it. That's not the point I want to make. My point is you can re-engineer competition law to deal with excluded groups. Yes, there are other institutional arrangements, but my point is simply that even if you remold antitrust, having done so, how much can you achieve? Is intervening in a few mergers, prohibiting the odd cartel, framing the theory of harm on the basis of protecting an excluded group really going to solve the big problems that have been identified? So what is the major sort of contribution that competition law can make, or what is the size of the contribution perhaps that competition law can make if we do reconfigure it? And indeed, more generally, do we need to rethink about remolding all of the legal institutions? So some of the suggestions that Dina made in her paper, referring to the work of Robert Hale, again, I'm just going to quote from Hale, we need a legal curb, a new body of law to restrain economic power. So then the question arises whether what we need is a more systematic rethinking of the legal system as a whole, rather than just the rethinking of antitrust. So some of what Dina suggests about corporations redistributing their wealth suggests that maybe rethinking company law and the objectives that we give to a company should be rethought, rather than just, or in addition to rethinking antitrust. But then the question is, should antitrust be part of the reformulation of economic regulation, or does it have such a marginal role to play that these efforts should be placed elsewhere? Likewise, Kati in her paper explains that a lot of women's work is in the home, and this is not a market economy. But then how well suited is competition law to address that which is outside the market? It takes a lot of effort to try to bring within the market economy household work, and then to integrate that into some sort of conceptual framework to think about a competition infringement in that context. And indeed, more generally on the feminist critique, if you look at it, most of it is about how badly the free market works, so that it identifies only certain elements and gives them market visibility and not others. So how can competition law as a market regulatory norm be used to challenge gender or even race inequalities? Do we have the right tools to do so? I suppose one answer to this would be to draw from Dina's paper, where she said, well, look, current competition law has been used to redistribute wealth to a particular segment of society, and all that these three authors are trying to tell us is, well, perhaps we need to now redirect antitrust in a different distributional setting to address and to protect other kinds of interests than the interests originally protected. And so if you then say antitrust is necessarily a distributive effort, then redistribution is then a more plausible approach. My third point is, are there trade-offs if we opt for the suggestions that have been made by the speakers? So for example, Dina in her paper says, well, South African law, racial inclusion is achieved at the expense of competition and lower prices. Likewise, Greg Day in his paper has a community welfare standard, and Kati suggests we need to perhaps prioritize certain cases where, from a gender perspective, there's greater harm to women, and that maybe is a more important case to take than one which causes other sorts of harm. But all these are choices that we need to make, and so what is the trade-off that we're making? And then things can become even more complex, because if we agree that we want to include historically disadvantaged groups, then it would be unfair to just stop at race and gender. So if you look at EU equality law, for example, that also includes sexuality, religion, and nationality. It does become a very broad enterprise. And then, sort of related to the trade-offs is also a bit of a paradox. So suppose we try to think about markets putting a gender perspective, and I'm just going to use the gender perspective because I have an example. Now, one of the points that have been made is that there's a data gap. And so sometimes looking at data about differences in purchasing habits of men and women gives us different results. And Kati has discussed some of this in her talk. Well, one of the cases that everybody brings up in this is a merger in the market for deodorants, where it is remarked that the companies themselves divided the products by gender. Sometimes in the 1980s, they decided that a unisex deodorant isn't going to give them as much profits as dividing deodorant into two. And so when these mergers are assessed, the competition authorities looks at male and non-male deodorant markets and divides them. Now, this was already done by the European Commission in 2010, so we're not talking about something that is reinvented. But what I find interesting, if you look at the decision, is that the decision then observes that there is harm on both the male and the non-male deodorant market, that the merger would create economic power in both. So to a certain extent, if we apply the approach which has been suggested by the Cseres report that was referred to before, to integrate data about purchasing habits and so on and so forth, it might well be that the theory of harm is that a merger harms male consumers more than female consumers. So to a certain extent, the paradox of trying to include more data about gender provenance might actually be that you don't necessarily protect the historically protected group, but you end up protecting men if the data tells you in this market men are more likely to be harmed than women. So maybe there's a bit of a caution there to re-engineer competition law using its ordinary tools, because that might just lead to results that are interesting, but not perhaps the results we were wanting to achieve in the first place. The fourth point is whether the gap is bigger in some jurisdictions than others. So Greg in his paper talks about mergers in the supermarket sector, which lead to the creation of supermarket deserts. So places where just disadvantaged people have nowhere to shop. But I wonder if that example is one where different jurisdictions might already have answers under ordinary antitrust law. So I looked at UK cases on supermarket mergers. And there, the competition authority observed that the competition parameter is not just price, but also location. And so the agency defines markets very narrowly to say each market should be defined within a radius of 5 or 10-minute drive for the consumer. And then the question is, after the merger, how many supermarkets are left in this very, very narrow market? If you think 5 to 10 minutes, that means creating lots of little circles across the UK to define different geographical markets. And by doing it in that way, then with these very tiny markets, then you avoid the risk of a food desert. So my point is here, by applying very ordinary economic analysis that factors in the right consumer welfare parameters, which is price and convenience, then one can already avoid some of the inequalities that have been there without necessarily reinventing the wheel. And indeed, writing about US antitrust, and Greg in his paper writes of the need to revitalize antitrust. And I found that word interesting because it reminded me of a paper published by the American Antitrust Institute in 2008 when Barack Obama was elected, entitled Revitalizing Antitrust, as it, because it had been sleeping for so long. But then if you think about it, the last 40, even perhaps 50 years of US scholarship can be seen as repeated attempts to resuscitate US competition law. So if you go back to Bob Pitofsky, 1979, The Political Context of Antitrust, Eleanor Fox's first paper on the Chicago School in 1982 in the Cornell Law Review. So maybe that is a jurisdiction which is a bit of an outlier in terms of having expansive theories of harm. So the point I want to make is that perhaps in some jurisdictions, the way in which competition law is interpreted could already, without explicitly opening up to race, gender, broader inequality, be able to encompass some of these issues. And perhaps if I have a couple of minutes left, just the last remark I wanted to make is about methodology of the papers. I thought what was really fascinating reading the papers is the very different literatures that all the scholars drew on to motivate their paper, and the challenge that this presents, because one is trying to kind of translate into a language of competition law terms that, or literature and ideas that resonate with great difficulty with competition law. So to some extent, people who do law and economics have a much easier task because the microeconomists are more or less speaking the same language as the lawyers. But I think, and compliment to the three speakers, these papers are really fantastic for showing us that it is also possible to integrate literature which at first blush appears very alien to the ordinary discourses of competition law and making it resonate. Okay, I'll stop there. Thanks.
Thank you so much, Giorgio. So I'm going to allow each speaker a couple of minutes to reflect, respond to, address Giorgio's comment, and maybe also reflect on the others' presentations. So Dina, please go first.
Thank you, Andy. Thank you so much, Giorgio. I think these are great comments, and I really enjoyed the presentation by Kati and Greg. Thank you for these as well. Maybe I'll pick up two of the four comments because I think my answers are somehow related to the first two. Is competition law enough? And if competition law has failed, should we sort of try to resuscitate something that has been completely unable to address some of these issues that we put on the table? And I would argue that actually, yes. And maybe that's my starting point here, is to say, well, for me, competition law is part of an arsenal of tools that regulates the market. So if we're at the end going to be talking about the market, maybe competition law has failed in a specific thing to, I don't know, regulate concentration and rising prices. But it doesn't mean that we shouldn't take all the other bits of regulating the market together. And I think that's why when you say, is competition law enough? I never think about competition law in sort of a bubble outside of regulating digital markets, but also intellectual property law, but just generally property law and contract law. And that's sort of, I think, the comment that you were making about the literature. I'm a law economist, but I'm interested in contract law, company law. And I think all of that, thinking about trust and thinking about all of that is somehow related. And I don't think by default, competition law will always be part of a combo of how we think about the market. And that's where I think that competition law is on the one hand so malleable, but on the other hand cannot be thought of in a silo outside of everything else. And that's why I think it's still useful to think about competition law as a tool to address some of these issues, whether it's gender or race or just economic inequality. And I think the three papers are really interesting to listen to and to read in this conjunction, as how can really compete, like we're all thinking from the lens of competition law, but we address really different perspectives and really different goals that I think is not impossible. Do we need to remold the system, refine it, or just think outside? I think this is the classic question also related to the trade-off. Can we revive the system, or do we need just something totally different? So are we within the matrix and can work within the matrix, or do we need to leave the matrix? It's Marx's classic revolution, or working within the system. And I think the three of us are trying to work within the system. So I'll answer for me and I let my colleagues answer for themselves. But for me, like, I've been very much invested in trying to address some of these ills of capitalism and injustices within the system. And maybe it's a mistake, and maybe it's to say, well, let's forget the system entirely and let's do something different and think about just general revolution and just reimagining the world. But I'm still somehow hopeful that given the malleability of competition law, given that it can work with all of these other systems and laws and regulations to like imagine things differently, I haven't given up yet. So that's my answer to that question. And then finally, the trade-offs. I agree. There are always trade-offs, but I resist really strongly to the argument, and that's often done, for example, in unemployment. If we raise minimum wages, we'll increase unemployment. If we make competition law focus on that, we're going to harm those that were intended to actually save. I think there's sufficient literature, sufficient heterodox and critical literature out there that challenges this assumption that if we want to protect the women, we're not going to end up helping the men. Like, I don't think that these dichotomies necessarily are where we end up. And I think my time is up, so I'll stop here.
Thank you. Kati?
Yes, thank you very much. These are excellent comments. I will also push back a little bit, while very well noted and great to have them, Giorgio. One is that, yeah, I think I'm also not arguing for re-engineering, even though I think we have to realize that we are living in a time that re-engineering or rethinking is happening due to many other things. If you just take EU competition law, we just don't know how it's going to be shaped, except that I don't think that the treaty is going to be changed, but just looking at what is the current portfolio, we just don't know how it's going to be rethought, but it's going to be rethought with all these issues around competitiveness and being part of a just and digital transition. So that's one thing. The other thing is that you said that it hasn't delivered what Dina said until now. Could it be that maybe it didn't deliver exactly for the issues that we raise? That these people or these groups, just thinking about the US elections, that women cared about it more. And with this, I just want to say, I think for me, it's also a kind of a scholarly and academic exercise of, looking into what happens if you look at these different groups of people and what it does to them, and having indeed a better knowledge. And what I noticed during my work is actually not that maybe I will convince you or anyone else in the call, but you start a kind of conversation with people who work in other fields or work with women rights organizations. And that's a kind of, it broadens the lens maybe of, so it might be the other way around, that competition law will be meaningful in other fields or in other areas. So that's just a little bit my feeling. And my last comment is, I think we talk about these three presentations as separate ones and one more issue and one more issue, but I think we largely talk about pretty much the same things. And if there is a rethinking, then I do feel, and coming from also a part of Europe where I'm actually working on something like that, do we know, for example, how Eastern Europe thinks about a competition law system? Because it's not always the same as, let's say, the Brussels bubble thinks about that and what has been the role of that. So I think it's pretty much with different methodologies and with different approaches, I feel like we talk about the same things. And I feel it's not expanding, but it's deepening and getting a better knowledge of indeed what competition law is for. So very well noted, and thank you very much.
Thank you, Kati. And finally, Greg, a couple of minutes for you.
Yeah, thank you so much. And I really appreciate this thoughtful comments. Obviously, if you read the papers very closely and thought about this, quite intently. And I think one kind of sort of theme that ran through a lot of your comments that I've been wrestling with too is the question of just is competition law up for this, And I think there's a lot of the people that have sort of written, about not using antitrust to worry about things like race or gender discrimination. That's essentially a lot of times their argument. It's not that they're not laudable goals, but just antitrust might not be the mechanism to do so. And I think that's a very valid critique. And I think we don't necessarily have an answer right now, but I think a lot of your points are accurate about sort of like, we don't need, and I completely agree. And I think that's a lot of my points in my later work is especially about how we don't need to like radically change antitrust to make it something different to achieve these goals, but a lot of the tools already sort of baked into it. And sort of like, as you mentioned, like, it's American antitrust has really embraced this like colorblind, we're treating everyone the same approach, where it's just failed to take common sense approaches. Like let's look at individual communities. Is there likely to be deprivation? Is there, it's the general thought is, will we have a bigger, better mega hospital, but we just assume that people in low-income communities can just take a bus to get there. And we've actually found out in practice that, that even cancer patients delay or skip treatment because they just live too far and need to take too many buses, to get there. And so I very much agree with your comment that, that a lot of these things would be solved if we just took a more common sense approach. And I think the trade-off question that you raise is the biggest issue, in the sense of, do we really, at what point is the bigger, better mega hospital in the affluent community better for everyone who can take a bus there, or what degree does it make sense to just make sure a lot of these facilities remain ran better distributed? Yes. Okay.
I was going to say 1 more minute, but you.
Oh, okay, 1 minute. No, so so anyways, it's just my way of saying that I agree, and I think that honestly, the trade-off question is the most difficult about, at what point should we favor, like, sort of like block an action because the minority community is harmed, even though the majority of people are helped. And gosh, I think that is the most fundamentally difficult question that I think we have to wrestle with. But I think if there is increasingly attention paid to this, that I think that a lot of times companies will sort of bake these considerations into their actions on the front end, so they can have protections. So they can tell merger regulators that we don't plan to shutter these grocery stores in these communities. And I think by focusing on it, we could just incentivize behavior on the front end before antitrust forces have to intrude.
Thank you so much. Honestly, a fascinating discussion, and the floor is open for questions. So please, no one's volunteered anything in the chat, but does anyone have any questions for our panelists? Well, if no one does it, I'm going to take the moderator's prerogative and ask a couple of, Joanna, please ask
the question. Maybe I have like question comment, because I'm wondering to what an extent, if we think about the practical consequences, and one of you mentioned this, to what an extent actually such an analysis would be helpful for the competition authorities to choose the cases on which they focus, and whether it is like the real practical application of this type of analysis. Because when we think about the resources that competition agencies have, and especially mentioning the Eastern European context and very limited resources, maybe this could be something that like the most like immediate consequence of these type of approaches.
Can I answer that quickly? I mean, I think that's an incredibly important point, is that it's not just about changing antitrust law, but actually changing antitrust enforcement. Like, one thing that I recently came across was in terms of childcare deserts in American, where especially it harms women, in the sense that they oftentimes can't take the ideal job that they want, or a job because they're forced to take care of their kid because there isn't affordable health childcare in low-income communities. But what I thought was interesting is one of the American antitrust authorities, the chief of it, said, I think last year, like, we're just learning of this. Like, we can't solve a problem if we don't know about it. And because they didn't know that this was a problem, but instead we're investing our resources in things like making sure Taylor Swift tickets are cheaper, and things like. And so I think that's actually like a good point, that we're oftentimes in the United States, we're choosing populist, cases versus the ones that actually would help people. And so I think the idea of enforcement versus the laws is a really good point.
Dina, Kati?
Yeah, I didn't get to the point of you may just guess, priority setting, but not just priority setting, market investigation. So they can be tools which will not require immediate and large resources, but help the agency to decide and make either a priority or not. But you can, I mean, thinking about luxurious watches, is that something that a competition authority would care about? So at the end of the day, it comes down to their own policies and what they feel democratically legitimate, what their role is in that specific society. And then I think we come back to what Giorgio said, that this may differ across jurisdictions, what these priorities are, because I can imagine that across the continents and countries, this might be differently set.
Yeah, and I don't have much to add, because I think that's exactly it. And the only thing that I could maybe just put out there is that this feeds into an overall policy perspective. So it's not just competition enforcement or changing the competition law, but changing an overall perspective of what competition policy is necessarily desirable that fits within a broader market policy and so on.
Thank you. Michal, do you want to ask your question, or do you want me to read it out?
Sure. No, it's just a follow-up on Joanna's. What happens when we have a clash between the different goals? I mean, how should we then prioritize?
Can I take this? I think number one is that which might happen is that, for example, sustainability, we often understand that as green and the environment. But that could be, of course, also social sustainability. So if you listen to the three of us, I'm not sure if it's conflicting goals or overlapping one. That's one thing. And again, I think we come back. This is the political setting of each competition authority, right? Where you will feel that whether it's, I could answer you right now that I think the Dutch Competition Authority would say, well, it's the environment and climate change and sustainability, which is our priority across others. But that's indeed something which will be largely defined of their political constituencies and the local interests they serve. And the last one, sorry to say that, for example, in the EU treaty, gender equality will certainly not win against sustainability, because the wording of that provision, which obliges the mainstreaming or the integration of the environment, is just so much stronger constitutionally than gender equality or animal welfare.
So just thank you, Michal. I think this is a great question and wonderful to see you. I think what is the way I see it is that these goals also, like agreeing with Kati, different context, but it also can change. So for me, it's not necessarily that in every single case and every single policy at every single across the board time frame will need to be this one specific thing, and then it will always be that. So obviously these things can change, and depending on the issue at hand and the moment that is being looked at, is it a moment, at least from my perspective, is it an industrial policy moment, or is it something else? And then these things can adjust and can change. And if it is an issue or an overwhelmingly race issue or gender issue, then this is put forward. And I was recently a reviewer of a dissertation that I thought was brilliantly written to talk about the intersectionality of competition law. So just changing the framing and using that method of just looking at these issues intersectionally and how they overlap, not necessarily as conflict, but as working together towards achieving these different goals.
Yeah, and thank you so much. That's a really tough question, and I don't have many perfect answers to answer. The only thing I can mention is also great to see you again. Is that I feel, I mean, antitrust does this all the time anyways, and so I think we already, like, for instance, like in the United States, there's a constant struggle about like when is innovation, when do we allow exclusionary behaviors that raises prices to occur, because innovation is also thought, because we often protect innovation and therefore excuse exclusionary behaviors. So I mean, so that's a huge trade-off: innovation versus competition and prices. So I guess the best I can really say is, I mean, this is something that antitrust has been struggling with generations, is how to balance perhaps competing goals.
Great, thank you so much. So there is a comment Thala made about an excessive pricing case in South Africa that speakers might be interested in. Thala, did you have a question or is that just a comment?
Hi, Wendy. Hi, everyone. No, more just a comment on, yeah, like this is a good opportunity to see, how, human rights and constitutional issues can be incorporated into competition law as well. And I think as Dina probably sort of mentioned, there was a constitutional law case in South Africa on mergers that also had a big consideration on the right to healthcare and looking at like uninsured patients and their access to healthcare and whether that the merger would affect that as well.
Great, thank you for your comment. We have time for one final quick question, if anyone has something to ask. No? Oh, no? Okay. Well, in which case, we're 4 minutes early, so I guess honestly, thank you so much to our speakers, Kati, Dina, Greg, and Giorgio for his incredibly insightful and engaged comments. Thank you so much for everyone for coming today. And before we leave, I do want to remind everybody that our call for papers for the annual conference next year in Chicago has been released. So please go and look at that. Make submissions. Submissions are due by the 27th of January. We would love to get all your submissions, and hopefully we will see you in Chicago next year sometime. But before we go, can we please just all have a round of applause for our wonderful panel of speakers and our discussant?
Thank you.
Thank you so much for all your time, and have a great holiday season, and good luck for the exams that are coming up and the exam marking that will inevitably follow.
Thank you.
Thank you so much, everybody. Have a great day.
Thank you. Bye.
Thank you, Wendy, for hosting and moderating.
Oh, that's fine. I'm happy to.